Hey, this is Brian Gibbons, and I just want to talk to you about the SAFE Act and the Dodd Frank Act. There are some things that are, not terrible about this legislation. Um, and one of the things that makes it good for real estate investors is the following. Um, why do people buy on terms? Because they can't get a loan otherwise. It's that simple. And right now, they are going to make credit tighter. Is that true or not true? If they're going to make credit tighter, then they're going to need to look at all the possible ways to buy. Same thing with sellers are going to have a smaller pool of buyers. Now, if that's true, then creative finance is going to be probably more popular. But you're going to have to mind your P's and Q's. So, let's just talk a little bit about, what happened. In July 2010, the Dodd Frank Act was enacted. Okay? And the way it was originally written is not the way it's going to be implemented. So it's very confusing. If you're reading something back in 2011 or 2012, it may not be correct today. Right? The CFPB, the Consumer Finance Protection Bureau, to me it's like the FBI. I mean, these people are supposed to be protecting consumers in all respects. Anything past January 2014, January 10, 2014, is going to be some different rules. So let's go through some things. What I like about it is there is what's called a 1 per year category rule. 1 per year category rule. The CFPB broke the seller financing into two different sections, two different categories. One category is for those individuals, trusts, or estates who do just one seller carryback transaction a year on a property that has a dwelling that a buyer will use as their primary residence. That's the big key. I'm going to repeat that. It's for individuals, trusts, or estates who do just one seller carryback transaction a year on a property that has a dwelling that the buyer will use as their primary residence. Okay? So this category is for individuals, trusts, who do just one seller carryback transaction a year on a property. Now for these folks, one, you can have a balloon. I've read all over the place that you can have a balloon, but you can have a balloon in your note on a buyer. So you can have a contract for deed kind of contract with a balloon. Two, you do not have to prove or document the buyer's ability to repay. You do not have to prove it. Three, the note must have a fixed rate interest for 5 years, and at the end of the 5 years, the interest rate can increase no more than 2 points per year with a cap of 6 points above whatever you started at. And you have to tie it to an index like the prime rate or the T-bill. And that's probably going to affect all but 3 to 5% of individuals who carry back notes or do seller financing. Remember, these restrictions only apply to seller carryback transactions on properties that have a dwelling that the buyer will use as their primary residence. What doesn't it apply to? Well, what if the property has a dwelling but the buyer is not going to use it as their primary residence? Like what? They're going to rent it out? Or they're going to use it as a second home? Then none of this applies. And you can offer seller financing with no restrictions. Isn't that great? No restrictions at all. Commercial property, multifamily, that are 5 units or larger are also exempt from these restrictions. Again, the one seller carryback transaction per year category applies to individuals, trusts, and estates. It does not apply to what? Does not apply to corporations, does not apply to LLCs, does not apply to partnerships or other legal entities. In that case, the second category applies, and we're going to talk about that. Again, these rules only apply to what the CFPB refers to as a residential mortgage loan. I'm going to say that again. It only applies to what the CFPB refers to as a residential mortgage loan, where the note is secured by a dwelling or residential real property that includes a dwelling. Now, most people only carry back the note once in their lifetime, where they sell a big house and they retire and they move somewhere else. Some might do it a few more times. Even some real estate investors only do it once a year. And these regulations are not a huge change for those people. Now let's talk about the more than 1 year category. Okay? The second category applies to individuals, trusts, and estates that do more than one seller carryback transaction per year, where the buyers will use a dwelling as their primary residence. It also applies to any seller carryback situation, even one of them, where the seller is a corporation, LLC, partnership, or other legal entity, and where buyers will use a dwelling as their primary residence. You see the difference? So here's category 2's restrictions. You ready? 1. The note cannot have a balloon, whereas in category 1 it can have a balloon. Okay. 2. The note must have a fixed rate interest of 5 years, and then at the end of the 5 years, interest rate can increase no more than 2 points per year after the 5th year, with 6 points above wherever you started at. You couldn't go over 6 points. And you have to tie it to an index like a T-bill or the prime rate in the very beginning. This is the same restrictions as the first category, exactly. Here's the third restriction. You must determine the buyer's ability to repay. Before, in the first category, you didn't. 4. If you do no more than 3 seller finance transactions per year, you do not have to become a mortgage loan originator. So 3 or less. 5. If you do more than 3, you must become an MLO, or find an MLO who is willing to be the go-between. So just as in the 1 year per category, these requirements only apply to seller carryback transactions on properties that have a dwelling that the buyer will use as their primary residence. Now, if you have a rental house and the renters want to buy the house to use as their primary residence, and you want to carry back a note with a balloon, and you don't do more than 1 seller carryback transaction a year, and that rental property is a corporation, an LLC, a partnership, or other legal entity, you're going to have to move the property into a trust or into your personal name. Otherwise, you're going to fall into the second category, which says you can't have a balloon unless you're an individual trust or an estate. I don't know who drafted this, but this is what, this is what it is. So if you think about it, not having a balloon but being able to do it at an adjustable rate is almost services the same purpose. But say you started with an interest rate of 6% on the note, and then after 5 years you adjust it, it goes up to 8%, and then it goes up to 10%, and then it goes up to 12%. Now, let's say if they don't refinance and pay you off, then you're rewarded for your risk of putting that paper together. How'd you like to make 12% on your money? And you don't have a balloon. You're just adjusting the rate. Now there's a whole new box here. It's called the ability to repay. The second category requires you to determine the buyer's ability to repay. But the rules, they don't specify any standards for doing it, such as the qualified mortgage standard, which is a 43% debt-to-income ratio, etc. You just, it's crazy. All that's required is that you make some good faith determination that they'll be able to afford the payment, and you don't have to document it. Now, in my opinion, when you think about, because this is the federal people, it'd be prudent to do some documentation in case, buyer gets an attorney. The reason why I was saying this, do you remember some of the attorneys for foreclosure rescue people? Are you being foreclosed on? Call us and we'll save your house. It's going to be a whole new ball of wax for attorneys that say, hey, if you can't pay your seller finance note, maybe they didn't underwrite you properly. So it's going to be a whole new industry. That'd be crazy, wouldn't it? So what if an attorney tries to create a legal defense against paying? But there's no requirement that you have to document. All it says that you should determine the buyer's ability to repay. Well, my recommendation, if you're doing a subject to and then a rent to own, or a subject to, then a contract for deed, or something along those lines, I would do an RMLO on that buyer, no matter what, and make sure that they have some ability to repay. I've heard from a friend of mine that called an attorney at the CFPB, and he asked a simple question: how does one determine the buyer's ability to repay? And he said, the attorney at the federal agency said that if you fall into category 2, you have to determine the ability to repay, but he admitted that there were no set guidelines. You just have to show that you use good faith determining. For example, the buyer has a job, his rent was $1,000 per month, but the payment on the note was $900 a month. So you think in good faith he can afford this property because he could afford the rental house that he was in before. I call it being prudent. What if buying the note created on or after the 10th of January 2014? If you're buying a note created on or after January 10th, 2014. So you're going to be able to tell from the note, by looking at the note, if the mortgagee is a private individual or it's an entity. So, if it's a private individual or a trust or an estate, ask them to sign an affidavit saying that they had not done more than 3 of these deals in a 12-month period, and how many of those had balloon payments. Now, if it's an entity, like an LLC or a corporation, ask for an affidavit asking how many deals it's done and how many of them had balloons. If there is a balloon in the note that you're buying from an LLC or a corporation or a partnership, there's not supposed to be a balloon. And that is if it was created after January 10th. You'd have to modify the note to remove the balloon before you buy it. Otherwise, at some point, the mortgagee could use the fact that the note was not in compliance, and it was written as, it could be written as a defense against paying the debt, or in a foreclosure situation. In summary here, I just think if you use an RMLO or you get licensed as an RMLO and you do seller financing, you buy it on subject to, or even if you do a lease option assignment, this is my opinion, and you underwrite the buyer and look at their ability to repay, and you pay somebody a fee to do that. If you do that, you'll stay out of trouble and you will be able to do a lot of seller financing transactions, even though the law doesn't require you to do it. I would still do it because the feds are involved. So that's my opinion. This is Brian Gibbons, Laurie Ice Skills. I hope this information has been helpful to you. And look at all the opportunities that the SAFE Act and the Dodd Frank Act have for real estate investors. I think it's going to open the door. Credit's going to get tighter, and we're going to have more opportunity. Thanks a lot.